Hello everyone, welcome to ImbibeMe. This video is brought to you by ImCard. Say goodbye to the old paper business cards and save the planet at imbibeme.com/ImCard. Get yours today. Back in the year 1982, Mrs. Victoria Gillick found contraceptive pills in her daughter's bedroom. She went to her doctor to ask, "Did you prescribe contraceptive pills to my daughter? I want to know. I want to know why she was prescribed contraceptive pills without my knowledge and consent." When asked about what the issue was, Mrs. Gillick said, "The issue is that my daughter is under 16 years of age." But the doctor turned her down, saying, "I'm sorry, I cannot give you any information about your daughter. I am bound to maintain confidentiality of all my patients." Mrs. Gillick, in distress, said, "You cannot do this. By doing this, you are promoting underage sexual activities. My daughter is still a minor. I shall take you to court for this." And the matter went to the court. It was a matter between West Norfolk and Wisbech Area Health Authority and Mrs. Gillick. Now it was a question of the rights of the adolescents who are no longer children, but the law does not regard them as adults. The court finally decided in favor of the health authority, saying, whether or not a child is capable of giving the consent will depend on the child's maturity and understanding and the nature of the consent required. Hey teenager, wait, things don't end here. And how can they stop? After all, it had to become an epic case. So let's go further. The case was then taken to the High Court, which again dismissed Mrs. Gillick's claims. The case was reapplied and went to the House of Lords. Judgment was once again in favor of the health authority. Judgment in the Gillick case at the House of Lords is referred to as the test of Gillick competency. This test of Gillick competency mentions that a minor must understand what is involved, including the risks and consequences of sexual intercourse, such as pregnancy or STI. The second point is that the minor understands the nature of the advice which is being given. If both these criteria are met with, then a minor is labeled as Gillick competent. Lord Fraser and the House of Lords thought, if the rights of these adolescents are not considered, they may continue to have sex, and if they are forced to involve their parents, this might stop them from visiting the health facilities for any medical advice and help. Thinking this, he gave his judgment about contraceptive prescription, which today in case of minors is better regarded as the Fraser Criteria. So the Fraser Criteria states that a doctor could proceed to give contraceptive advice and treatment to a girl under 16 if the girl is Fraser ruling competent, which means that the girl should satisfy these 5 criteria. 1. The doctor cannot persuade her to inform her parents. Second, that the girl is very likely to continue to have sexual intercourse with or without contraceptive treatment. Third, that it is in the best interests of the girl to give her contraceptive advice, treatment, or both, even without parental consent. Fourth, that even if the girl is less than 16 years of age, she understands the advice. Fifth, that her physical or mental health are likely to suffer without contraceptive advice or treatment. Well, that's about the story behind it. But now let's see, how do I apply this information when a girl comes to me at consultation? Well, the first step is that I would assess Gillick competence, which means assessing if the minor understands the situation in all its perspectives. First is, can you explain to me why do you need contraception? Second, what would happen if you do not use contraception? And the third, do you know some of the risks of being involved in a sexual relationship? Only if the minor understands and is able to answer these 3 questions, then the Fraser Criteria would apply. So to apply the Fraser Criteria, the conversation between me as a consultant and a minor would include some of the following questions. First, do you think you can try and talk to your parents about your relationship? If the girl is ready to talk to her parents, then the Fraser Criteria does not apply. And then I would ask the girl to get her parents along, and then the discussion would go ahead. But if she says that she cannot talk to her parents, then I would ask the other questions. So the next point is, I would ask, how would you feel if you are not prescribed contraception today? The third would be, if you are not prescribed contraception, question, do you think that would stop you from being in a sexual relationship? Well, if the child cannot be persuaded to inform her parents, and even non-prescription of contraception would not stop her from being into a sexual relationship, then I would go ahead and prescribe contraceptives to her. Before that, yes, of course, I would rule out some of the contraindications of contraception. If the minor is less than 13 years of age, it is important to identify that it is an unlawful sexual relationship, and the law in UK does not permit sexual relationship below 13 years of age. Gillick Competence and Fraser Criteria give the minor individual a right to consent to treatment because it is in the best interest of their health. But the right to refuse a treatment is not usually provided to the minor individual. All said and done, the minor groups of individuals are at an increased risk of being subject to abuse. So the things don't end here. The underlying statement is that there has to be an individualistic approach in all these cases. That's all for today. ImbibeMe signing off. ImbibeMe, a part of the ImbibeMe family, at imbibeme.com/ImbibeMe.